Welcome to Expert Views on ADR EVA, a podcast about simplifying the traditional African method of settling disputes or the appropriate dispute resolution, ADR, in a bid to attract more users to settle their disputes or conflicts with mediation, ombuds, collaborative law, arbitration, restorative justice, early dispute resolution, negotiation, conciliation, and of course, early neutral evaluation. My name is DrChinweEgbunike-Umegbolu, the host of Expert Views on ADR EVA video podcast show, and I'm delighted to welcome Miss Ashley Andrews to the EVA show. She is a top-rated attorney practicing in California. Miss Andrews was selected to Super Lawyers for 2021 to 2025 with nearly 20 years of experience in family law. She is renowned for her dedication to helping families navigate the complexities of divorce and related matters. As the founder of Ashley A. Andrews ABC, she combines her strong advocacy skills and creative legal mind to deliver compassionate and effective solutions for her clients. Her firm specializes in mediation and collaborative divorce. She wears many hats, so I've left a link to her profile. Welcome to the show, Ashley. Let me stop sharing on my screen.
Thank you so much for having me.
It's such an honor to have you. So without further ado, the first question is, what is the role of family mediation in dispute or conflict resolution? Thank you.
Yes. If conflict resolution was a play, family law mediation would have a leading role for 5 reasons. It de-escalates conflict, offers creative solutions, allows family law mediation participants to control the time, place, manner, and outcome of their family law issues, facilitates release of emotions in a safe environment, and, my favorite, reduces unnecessary fees and costs by encouraging open discussion and transparency without the need for formal discovery and court appearances.
Oh, thank you so very much. I like the way you summed it up. I'm gonna take that and start using it. Thank you so very much. That's a good summary of what family mediation is and its role in conflict resolution. So what are the laws and regulations that guide family mediation in the U.S.? Thank you.
Yes. So my practice is limited to California.
Mm-hmm.
So we focus on the California Code of Civil Procedure, the Rules of Court, and the California Family Code, as well as extensive case law from the state courts.
Oh, okay. All right. Thank you so very much. So do you, what is your take? Do you think that family mediation differs or has some similarities with the usual mediation? Thank you.
Yes. So the similarities between family and general mediation are the tools utilized to help the participants reach resolution. Okay. So the tools are the same. The differences, however, are the subject matter.
Oh.
You know, family law is a moving target, right? So you deal with kids, they grow older, they have preferences, they have sports that change each season, and these changes impact parenting schedules and the amount of time each parent can spend with the children or with a child. So when parenting schedules change, child support amounts may need to be adjusted up or down. If spousal support is an issue, then it may need to be modified upwards or downwards, depending on changes in income, ability to be self-supporting, and whether a supported party enters into a new relationship. And finally, in family law, property division is in flux too, as assets may need to be sold, transferred, valued, and divided. This takes time. It takes analysis, right? It takes data collection and the introduction of experts.
Thank you so very much for that elaboration. I wanted you to sort of explain what are the tools you mentioned for when you talked about the similarities between the two. Thank you.
Sure. So the similarities are, we operate utilizing the book Getting to Yes, right? We separate interests from positions. We utilize empathy, right, with the participants.
Yeah.
And, you get into the BATNA, best alternative to a negotiated agreement.
Okay, thank you so very much. So what do you think? Do you think that domestic violence, can it be mediated? What's your take?
It can be mediated. I have mediated cases with domestic violence, but, and this is a big but,
yeah,
it must be done carefully. I think in domestic violence situations, both parties need his or her own attorney in the mediation room. I think that separate breakout rooms at all times are warranted when there's domestic violence.
Yeah.
And, further for everyone's safety, I think it's best to mediate these cases on Zoom.
Okay. Well, thank you so very much. So I think when you talked about similarities and differences, I forgot to ask you, what do you think about parties? The general saying that when parties mediate, they do not bargain or negotiate in the shadow of the law. It's I don't know, what do you think about that? Do parties bargain in the shadow of the law when they are mediating via family, or do they negotiate in vacuum? Thank you.
Well, in California, we have disclosure requirements.
Okay.
So the parties can, deviate from what the law would award a party, maybe in terms of custody or support or property division. So they can use that as a basis for their negotiations. But we still need disclosure. We still need informed consent. So, they can deviate as much or as little as they like in mediation, which is great. A court will not do that. You can do that in a negotiated divorce or a mediated divorce, but there's still the requirement of disclosing, right, income, assets, and debts.
Okay, thank you so very much. So let me take you back to this question. When I asked you whether the domestic violence can be mediated, and you said, yeah, and then you sort of explained to what extent one can mediate domestic violence. And I also want to ask you, what are the psychological impacts on the power imbalance in mediating such cases? Thank you.
While the mediation participants may have power imbalances going into the mediation, okay, while in the mediation, those power imbalances should be addressed and remedied. And if the mediator is trained and experienced, then she should be able to perceive a power imbalance and rectify it immediately with tools. So here are some examples of these tools. Okay. You have consulting attorneys for each participant. You could have forensic accountants. You could do a mini child custody evaluation. You could have an attorney appointed for the child. And mental health professionals can be brought into the mediation to rectify those power imbalances. So, all of these tools can and should be brought into the mediation when those power imbalances exist.
Hmm. Oh, thank you so very much. So what if we take on board bringing in lawyers, professional health into mediation? Do you think it's gonna cost much to now mediate when compared to litigation?
No, I think it'll cost less.
Oh, okay. Yeah. Okay. Thank you so very much. So, can you please expand on the implications of legally binding prenuptial and postnuptial agreements? Because in some jurisdictions, these are not quite popular or used. If you can enlighten my audience. Thank you.
Yeah, the implications are profound. Okay. So, for example, a woman could waive spousal support in a prenuptial agreement, okay, be a stay-at-home wife and mom for 20 years, right, divesting herself of her earning capacity, and then should the husband decide to divorce her, she has no income. Right? So, so would this prenuptial agreement be enforceable though? I don't know. It depends on the circumstances under which it was signed, whether she had her own attorney, and what property she would receive in the divorce or has as her separate property. So legally binding prenuptial and postnuptial agreements can be great things, can be very promotive of marriage. They can be also very damaging things. They can be disastrous.
Oh, well, it's good that you highlighted the disadvantage as well. Oh, okay. And so, as an attorney, would you advise your clients to put that in their agreement, or they shouldn't? Did you hear me?
You know what? No, I could not hear the question.
Oh, I said, as an attorney, what would be your advice to your clients, whether they should add that in their agreement or not to add that?
A spousal support waiver?
Oh, okay.
Is that what you're asking? If they should add a spousal support waiver?
No, I'm still talking about the postnuptial and prenuptial agreement. So, yeah. Would you advise your clients to put that in place?
I really think it depends on the circumstances of the parties.
Okay.
I think that premarital agreements can actually be promotive of marriage. They facilitate transparency. They, address very sensitive issues in a marriage, the finances, right?
Yeah.
And I would say that the vast majority of my divorce cases that I handle are for financial reasons. So if people who are contemplating getting married put together a premarital agreement, forcing themselves essentially to address those financial issues at the start, then I think it could be a very good thing. But
okay,
yeah, the premarital agreements, they need to build up the marriage. I see a lot of premarital agreements that keep everything separate, and that to me is not a marriage, and I don't see those marriages lasting in my practice. I think it's best, in addition to the transparency, that the premarital agreements are used to build an interest in the finances for both parties.
Okay, thank you so very much for that. And so what is your advice for potential users or people pursuing a career in family mediation?
Yeah, I think that family law mediation it should be mandatory for everyone going through a family law matter. And in fact, in Los Angeles County, it's required that the parents or the divorce parties go to child custody mediation. Now, whether they're prepared for it and whether the 1 hour of time that they're given by the court is sufficient, that's a different discussion. But I think it's best to try family law mediation and start right away. Yeah. I also think that it's best for each mediation participant to have his or her own consulting attorney. And that goes back to your question of whether that will increase the cost. There will be a cost associated with that. I don't think that it increases the cost. And I think that there are tools that the mediation participants can put in place, like a disqualification clause for the consulting attorneys, that will, keep that cost under control. And I'm happy to elaborate on what a disqualification clause is.
Oh, yes, please.
So consulting attorneys can sign an agreement that if the mediation participants decide to litigate the case, they will lose the relationship with the consulting attorney and lose the work product. So what that means is the attorneys can't say to the mediation participants, you know what, I can get a much better deal for you in court, so let's just go to court, right? Which I see a lot and I hear a lot in my litigated cases. I'll sit down with the other side, we'll try to negotiate an agreement, and the other attorney will just throw up his or her hands and, in an exasperated state, march out of the room screaming, I can go get a better deal in court, which is not necessarily true. In fact, I'd say about 100% of the time it's not true. Why attorneys do that, I don't know. But when you have a disqualification clause, you don't have that issue. You have everyone in the same boat rowing together, right, towards a resolution that both mediation participants can live with.
Interesting. Thank you so very much for sharing that. So what is the future of international legal research via podcasts, particularly in family mediation?
This is a really interesting question, right? And so it makes me wonder if the market will become saturated, right? Will we suffer from analysis paralysis because there's just so much information in there? Or, will all the information available lead to confusion and the resurgence of the revered expert, right? Office appointments and one-on-one in-person meetings. I don't know. I don't know if it's going to be something great and useful, or if it will be something that will just cause more confusion and bring people back to the very thing that maybe they should have started with, which is, right, an office appointment with a professional. I think it could go either way.
Okay, thank you. Thank you. So what is can you tell me more about Ashley A. Andrews, APC?
Yes. So I founded my law firm in 2010 with the vision to provide my family law clients with the best procedures, practices, and professionals with around-the-clock support. And my vision has not failed. We're successful in this endeavor. Okay. Always try to settle a family law case and encourage parties to mediate their family law matters, either with us, a private judge, or with another attorney, such as Forrest Mosten. I know he's been a guest on your show. He's a wonderful mediator, and I have him in a lot of my cases. We can certainly litigate a case as well. Our clients consist of self-made millionaires, entrepreneurs, small business owners, clients with intellectual property, second marriages with extensive property, clients with special need kids and blended families, and of course, prenuptial agreements.
Oh, thank you so very much. I also want to ask a final question. Can you provide 5 tips for crafting an effective introductory mediation statement? Thank you.
Yes. So mediation statements are a very interesting animal. I've seen them work beautifully, and I've seen them actually turn people off to the mediation process. So when we're talking about the statement, I presume that we're talking about, the statement that the mediation participants make at the start of the mediation, right?
Yeah.
So first, I think it should be thought out and run past the mediator and a consulting attorney. I don't think that the mediation participants should be told the day of the mediation, by the way, it's time for you to give a mediation statement. I think that this mediation statement is like an opening statement in court for a trial. It has to be very, very carefully put together, very carefully crafted, practiced, because it sets the tone for the entire mediation. Okay? I think that the mediation statement can be emotional, but not an attack on the other mediation participant. It should show some vulnerability. It can contain an apology. I've seen that work very, very well. And, I think that it could specify some goals for the mediation. I would really like to do this, or I would really like to do that, or, I did this in the past and I'm sorry about it, and this is what I would like to do in this mediation. I think those are great ways to get a mediation started.
Thank you so very much. I know I said it's a final question, but I have one more question. I want to clarify whether mediation is mandatory in California.
In family law, in certain counties, the parties are required to go to mediation before litigating a child custody case. Okay, that's the first thing.
Okay,
and then in some counties in California, there is what's called a mandatory settlement conference before a case can go to trial. Okay. And in this mediation, or this mandatory settlement conference, the family law parties are given, maybe an afternoon with the judge, and it could be one afternoon or two afternoons. Is it enough time? I don't know.
So what happens if when you have recalcitrant parties that do not want to settle? Do they sort of give them cost sanction, or
Yes, that's a fantastic question. So in California, if you have a party on the other side of a family law case who is engaging in scorched earth practices, or maybe is a narcissist, is enjoying controlling the other party, or there's domestic violence, right? And as part of the domestic violence, they're litigating the case as further abuse, right? There are three ways that you can handle that situation. Number one, you can get an attorney fee award right away. California is a need and ability to pay state. So if the other side that's engaging in this behavior has more assets and or more income, you can dissuade them from continuing on with that behavior with a very large fee request and possible fee award. Okay, that's the first thing. The second thing is, and I do this a lot in my practice, where I'll have the other side send me very aggressive, inappropriate discovery, just a number of emails and attacking correspondence. I will send them a warning letter that says that if they proceed on with this conduct, I'm going to seek sanctions against them pursuant to California Family Code Section 271, right? You have to be reasonable in your communications. Additionally, we have a case called Davenport. And Davenport sanctions, those can be issued if the attorney on the other side is over litigating the case. So I will get a fee award, I'll issue a 271 and Davenport sanction letter, and then if those things don't work and the other side is still desirous of going to trial to continue to perpetuate whatever their agenda is, then I won't set a trial date until I get a very large fee award for trial, and I will back up my request, right, with all of the documentation showing the behavior, the pattern, and the warning letters. And it's very unfortunate when that happens. But it does happen. And so whether we can, mediate those cases and get them into mediation, sometimes we just can't. And, we have to go to court and use one or more of those three mechanisms to get the other side to be reasonable.
Thank you so very much for your insights, perspectives, and the learning you've shared with us. Of course, this is a masterclass, and I believe that potential users will take on board all you have stated herein and opt for family mediation or ADR, whenever the case arises. Thank you so very much, Afi, for coming on this show. I truly, truly appreciate you.
Oh, I appreciate the opportunity, and I think the work that you're doing is really fantastic. You're attracting wonderful people, present company excluded, and keep up the great work.
Congratulations for being awarded or appointed a super lawyer. That's awesome. Incredible work you've done so far. So well done. Well done. All right, you take good care of yourself. Cheers. Bye.
Bye-bye.
Bye.